Today, more than ever, parents want to be involved in every aspect of decision-making for their children. When should separated parents have equal decision-making for their kids? Hi, my name is Thomas O'Malley. I'm an experienced family lawyer in Durham Region and the GTA. April and Nathan have joint custody of their sons, Jacob and Richard. April wants to change the court order from joint custody to sole custody. These parents have been involved in endless fights and conflict over their children. These disputes have included miscommunication and deliberate failure to communicate about medical issues affecting the kids, conflict about the choice of health care providers for the children, for example, a natural path versus a medical doctor, enrollment by Nathan the father of the children in activities despite the objection of the mother, which impacted the children's time with their mother, audio recording of interactions between the parties and between the children, and the other parent, video recording secretly the father and the kids, and the father then penalizing the mother afterwards by withholding the children from her to make up for his lost time and making her late for work, and involvement by both parents of the local Child Protection Society and the police. One thing that parents can learn from April and Nathan is, but before I explain what parents can learn from this situation, let me point out the factors which tend to show whether parents should or should not have joint custody of their children. First, joint custody should not be ordered where there is poor communication and the parties fundamentally disagree on too many issues affecting their children's best interests. 2. Courts do not expect communication between separated parties to be easy or comfortable or free of conflict. A standard of perfection is not required and is obviously not achievable. The issue is whether a reasonable measure of communication and cooperation is in place and is achievable in the future so that the best interests of the children can be ensured on an ongoing basis. 3. Where a conflict between the parents, such as an inability to communicate effectively, is primarily the fault of one parent, that parent should not be able to use this conflict as a justification to oppose a joint or shared parenting order. To do so allows a difficult parent to engineer a result in their favor. However, where the conflict is extreme and there is substantial blame to be leveled against both parents, a joint or shared custody approach is usually not appropriate. The court found that April and Nathan had too much conflict in their situation to keep a joint custody order in effect. The court found that April should have sole custody of Jacob based on the facts of that case. Make sure you spend some time with your family lawyer discussing this very important issue in your separation or divorce. If you have any questions about your separation, divorce, or family law case, and you would like our help, there's a few ways to contact our office. You can leave a message on my Facebook Law Office page, visit my website at www.canadiandivorcelegaladvice.com, or call me directly at 905-434-8837. We would be happy to speak to you. Oh, by the way, did you know you can protect your family law rights and get essential information on settling your family law issues with your former spouse with the daily, indispensable family law advice and tips on my free Facebook group? Go to Facebook and search Durham Region Separation and Divorce Legal Support Group in the top search bar. You'll find the group and join. Thanks for watching this video and have a fantastic week.